Okay, I'm on. Toot, 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 toot.
So good afternoon, everybody. We have, let's see, 3 of us here, and we're expecting about 9. And so what I plan to do is I want to talk for, probably about 5 minutes and say things that are kind of throwaway, that if you miss it, it's not that big a deal, to let other people have a chance to get connected. And the first thing that I'll say is, right after we get done with this today, we're going to, well, the first thing that's going to happen is there's a Google Drive that right now there's not very much. There's just the affirmative constructive for one very early stages affirmative that's probably good enough for a practice round. But over the weeks and months ahead, more things are going to appear there. We don't ever want it to become like a source book, like a replacement for doing your own research and your own argument construction, but just kind of proof of concept, just kind of something to be a resource, not anything you would ever take to a tournament. The second thing that I'll do, just to give people, and we've been joined by more people now, just to give you a couple of seconds to get your technology in order and everybody settled and so forth, is I was noticing that on the Stoa website there is a document that just went up about, I think, 18 hours ago, and it said that the free speech and community standards topic would be the preferred topic from October through the end of January, with the letter of the law, spirit of the law picking up in February and going to the end of the season, but that it would be tournament director's choice all season long. So what I plan to do is I want to start off today. I am going to talk through some of our beginning ideas for both topics, and then we can spend the balance of our time. You can throw in your own ideas, and we can have kind of a brainstorming session, or you can ask me about any of the ideas that I've thrown out there. So that really is pretty much my overture. That was a little bit shorter than I wanted it to be, but what I think I'm going to do right now is I'm going to fiddle with WebEx until I can figure out how to show you my desktop, and I have a PowerPoint that I'm going to go hide behind for probably about 5 minutes to talk through that opening salvo of ideas, and then we'll make this a little bit more interactive and a little bit more of a conversation. Let me see. There it is. And it would really help if everybody would mute their microphones until we get to the point where we're going to have the conversation, because yesterday we had a much bigger group, but we actually ran into some feedback problems and people didn't have their mics muted. So do us a favor and do that. Okay, so the first topic, the free speech and community moral standards, I was really, really surprised when this won the voting. It's been used before in a couple of different leagues, but if you go and you do a search for free speech and community moral standards, what you're going to get absolutely drowned in is court cases and law review articles about where's the line between pornography and obscenity. And I thought, is that what this league wants to debate? And I thought, because you have to describe so many actions, sexually explicit actions, and say what the standard is for saying whether that's protected by free speech, what we have kind of generated here are some ideas to let you dodge that. And I want to mention that at the beginning to say, that's out there. The phrase community moral standards in First Amendment jurisprudence appears nowhere as often as it does in obscenity trials. So you may need to give a little bit of thought to, I would assume that's not something you want to write your affirmative about, but you might need to give some thought to what will you do on the negative if you've got a really, really daring affirmative opponent who did take that for their affirmative. The thing that I think is kind of hopeful is, given the way the topic is worded, the affirmative would have to say that free speech defends, free speech protects things that are in that kind of subject area. And so I think you'd have probably an easy time of it, but I don't think you can ignore it altogether. And probably at least once during the season, you'll be aware of someone who decided to give that a try. But everything from here, we have got 7 ideas for ways to go on the affirmative that are not about that. And the first 2 I would describe as, we kind of labeled them the best defense is a good offense affirmatives. And the first of those is the one that is up in the Google Drive right now, and it's just called the moral progress affirmative. And the idea here, the value in that affirmative is moral progress. And the premise it begins with is that morality doesn't necessarily change. Right and wrong is right and wrong. But through the generations, we get better and better collectively at understanding it, and our community moral standards actually improve. But the only way that can happen is through free speech. And what you do then is you can talk about a lot of different controversies over the years where things formerly thought immoral. We've come to understand that they're not immoral because there were people who spoke out and challenged the moral standards. And right at the point where they did so, that was upsetting. That violated social norms, but that was something that had to happen, and that's the only way that moral progress can happen. So we call that the best defense is a good offense, because what you're trying to do is you're trying to steal the thunder of the negatives ground. You're trying, the most logical thing that they're going to do by defending community moral standards is to say that that's how you preserve moral behavior. And if you can undercut that by saying that can only operate if you've got free speech to ensure continued moral progress and the purging of that system, then that I think has some promise. I'm not really sold on that, and that's at the beginning of our approaches, because there's another one that's also kind of the best defense is a good offense. That is from a book by M. Scott Peck. The book is called The Different Drum, and when I bring the camera back, I have a copy of it and I can hold it up. And what he talks about in a number of chapters in this book is how community is built, and the difference between authentic community and pseudo-community. And pseudo-community, he makes the argument, is all about avoiding conflict and avoiding chaos. And he talks a lot about how free speech is actually necessary to build and strengthen community. So I think you could put together kind of a slick little affirmative that would say that a community that doesn't tolerate free speech about even the most troubling controversies is a dysfunctional community, and that could go right to the heart of some of the strongest arguments on the negative. So those are the two approaches that we kind of lump together and call the best defense is a good offense. Now, a third approach, there are two variants on this, but we call them the patriotism affirmatives, and one of them is flag burning. And if you want to get into that literature, those arguments are very well developed. You'll find law review articles, you'll find entire books. There were a couple of Supreme Court decisions with the justices making arguments on both sides. And I think the position that flag burning ought to be protected by First Amendment free speech protections is actually a pretty tenable one, and it holds up pretty well. When that has been affirmative ground in Lincoln Douglas topics over the years, it has a fairly good track record. And the other variant on that, the more recent one, is the one associated with the Stolen Valor Act, or the Stolen Honor, I believe. It's either Stolen Honor or Stolen Valor, but there was a law passed after there was a military officer who claimed that he had won the Congressional Medal of Honor, and he actually enjoyed a whole lot of benefits, a whole lot of positive press coverage. He, I believe, was even on the lecture circuit. And Congress passed a law, after it became clear that that had all been fraudulent, Congress passed a law called the Stolen Valor Act, and it went to the Supreme Court, who struck it down on free speech grounds and said, you know, there may be ways that we police this, and there may be ways that we try to make sure that people don't commit that kind of fraud, but criminalizing the act of saying that you won the Congressional Medal of Honor, that's impermissible because that's too much of an incursion on free speech. So I think you could almost use that as an updated version of the flag burning affirmative. And that would be kind of a defendable angle on the affirmative end of the topic where there are fairly developed arguments out there. You just need to go out and read up on them and find what they are and get really fluent with them. Okay, so those two are the patriotism cases. The fourth approach is, I think this is actually one of the most promising ones, and this is the next affirmative that we're going to put together and put up our proof of concept in the Google Drive. And that is, there's a Supreme Court decision from a long time ago, Chaplinsky versus New Hampshire, and it's one of the limits commonly put on what the First Amendment protects, the doctrine of fighting words. And the phrase that really caught our eye, this is from the majority opinion in the decision, fighting words are defined as those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. It's been well observed that such utterances are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. And the fighting words doctrine has been around for a very long time. I want to say this case goes back to the 1920s. But there have been very few, I would venture even to say, some of the legal scholars are saying no convictions upheld on the fighting words doctrine. And there are some fairly well thought out and fairly well developed critiques of the fighting words doctrine that say it just needs to be done away with. And so I think you could have a really easy to explain and really appealing affirmative that was about how the fighting words doctrine perfectly illustrates the clash between free speech and community moral standards. And then you've got that developed critique to say it's misguided to say community moral standards should be the check on free speech. Okay, that's the fourth, 3 more to go. You could have an affirmative about hate speech. And there are a lot of people who write in depth about the distinction between hate speech and a hate crime. That if you commit a hate crime, if you do something violent or if you damage people's property and that's motivated by hatred for the immutable characteristic, that's one thing. And there may be rational reasons for there to be a sentence enhancement for that. But criminalizing speech just because it targets an immutable characteristic, that there are serious coherence problems with. Now, the reason that that's taking on kind of a hornet's nest is there are also very developed arguments made the other direction that hate speech falls into a different category. So this may be an affirmative that you find appealing, that you're interested in, and it may be eminently winnable. It will be a lot of work because there's a lot of ammunition on the side of people who are putting together the negative against it. Whereas if you go with something like fighting words, you will not find very many people developing the argument that the fighting words doctrine is actually a good thing. So I've always been a believer when you pick your affirmative, pick the one that gives you kind of a downhill battle and where your opponents are going to have to kind of scramble to find something that's a winnable position. Okay, I think that you could write a pretty good affirmative that would be very appealing to the judging pool about prayer in schools and other examples of religion in public life. The American Center for Law and Justice has been winning these cases before the Supreme Court for the past decade or two just by like clockwork, because for a long time, the strategy that people who were trying to protect the role of religion in public life that they took was to try to claim the First Amendment Establishment Clause, that Congress shall put no restriction on the free exercise of religion. Well, the American Center for Law and Justice took a completely different direction, and they said that the practice of religion in public life is actually a free speech issue. And that was unbelievably hard for their opponents in the appellate ladder in the federal courts to answer. And it was something that just about all of the judges were voting for pretty consistently. And so what I think you could do, the rub would be how to make the argument that public expressions of religious faith in the public sphere, in places like county courts and so forth like that, you'd have to make the argument that by community standards that was immoral. And that would be a little bit of a struggle, I think. You could find research about how the United States gets more and more secularized every year, but you'd have to put some ingenuity into saying that public expressions of religion countered community moral standards. But after that, if you can do that, then you've captured the tension in this topic wording. And I think that defending that free speech ought to cover religion in the public sphere would be a pretty easy sell. Now, you probably would have to say that it was all religion, which means Muslim prayer, which means everything that goes along with that. Your negative opponents would have the option of saying, what about the people down in Oklahoma who put together a memorial to Satanism that they won't put outside the courthouse? And you would have to think about your defense of that, because that would come with this. But this is an approach that I think at least deserves an investigation. And then the last one, you might think that there's nobody who defends tenure. And by tenure, I'm talking about the working conditions, the working contract that some college professors have and some K-12 teachers have, where once you pass through a probationary period, you can only be dismissed from your job for cause. You have to be charged with misconduct. You get a chance to answer those charges. And absent that, you cannot be dismissed from your job. And the thing about that is, tenure at its heart was supposed to encourage educators to be able to talk about unpopular ideas without fear of reprisal. And, you know, whatever my personal thoughts about tenure, I teach at a college that doesn't even have tenure. Whatever my personal thoughts about it, if you go to Google and you put in just the search phrase, in defense of tenure, you'd be surprised how many people have written fairly lengthy works that go into why, and including a couple who label theirs, a conservative defends tenure. You could get, I think, some pretty original and pretty appealing arguments that tenure is a good thing, and that tenure is a perfect example, kind of a contained example, of protecting free speech when it comes in conflict with community moral standards. Okay, so those 7 approaches were the ones that we thought, at least at the beginning, had some promise on the free speech community moral standards topic. Let me talk about just a couple of negative approaches, and then I want to talk for a few minutes about letter of the law, spirit of the law, and then we'll turn this into a little bit more of an interactive conversation. Okay, I have to admit, we were not collectively able to come up with a whole lot of negative approaches. We really only came up with 2, but we'll share those 2 with you, and then we'll see if we can get more into discussion. My sense is that with a lot of the affirmative approaches, what's going to be the winning strategy is not to put a lot of investment into your negative case, but to be prepared to do a lot of direct refutation. But a couple of negative approaches that might have some promise. The first is, this is one that has been used on topics in the past. It's kind of a clever strategy. You first say that the absolutist view on the First Amendment is absurd. The view that the First Amendment is absolute, that no restrictions on free speech are permissible, that leads you into all kinds of paradoxes and contradictions and absurd situations. So if we're going to discard absolutism, then we have to admit some restrictions will be placed on free speech, whether it's fire in a crowded theater, whether it's time, place, and manner restrictions, there will be some. And then use the negative, ask the question, where should they come from? And then you make the argument, the best source of restrictions on freedom of speech are the standards of the community, that the community should be engaged ideally, the community should have a voice, that whatever limits are going to be placed on the extremes of free speech, they should conform because of the nature of open and liberal democracy, because of the nature of consent of the governed. That's the best source of restrictions if there have to be some restrictions. So that's kind of a nifty little move, I think, to be ready with on the negative. And the second one that occurred to us was the communitarian view. And we started off thinking about, there's a classic law review article from 1984 by a law professor by the name of Peter Gable about alienation, and it's called The Pact of the Withdrawn Selves. And he makes a fairly developed argument about how when we try to solve our problems by making rights claims, what that does is it breaks down the ties between us. And I think you could make a pretty good argument that we are living in a time where we're already very, very alienated, and what we don't need to do is make it worse. And use the negative could defend how powerful and how important community cohesion is, functional, mutually supportive community, how important that is. And you could say that dealing with controversy by letting people stand on their First Amendment rights is corrosive to community, and I think that would have some appeal. And then you could back that up with some of the other communitarian philosophers like Amitai Etzioni, like Marianne Glendon, and there's a whole long list. So those are two possible negative approaches. All right, that's all I have to say as an opening salvo on the free speech community standards topic. The other topic I have to admit is in some ways my dream come true. For 2 or 3 years now, I have been proposing in very clumsy ways that an LD topic, and I've sent it into both Stoa and NCSCA, should match up Antonin Scalia on the Supreme Court, his interpretive approach, with the interpretive approach of some of the other justices. He is a textualist. He says that the only thing a judge ought to do is look at the law, figure out what does the law mean, and be done. And what some of the other justices on the court will do is they say that the law is a living document. And especially when you deal with the Constitution, which is well over 200 years old, you have to take the concept behind it and apply it to the facts as they are today. And they'll make the argument that the framers could never have understood what kind of circumstances we would be in today, so we'll try to kind of recreate what their purpose was. And that's such a good controversy because the arguments both ways, they are written down, they have been debated in the literature to the 4th and 5th line of extension. There's so much to learn by reenacting that debate. So I've sent in these long-winded, completely convoluted versions of how to word that as an LD topic, and it just hit me. This topic is that topic, federal jurisprudence, and the letter of the law and the spirit of the law. So where I'm going to open up to talk about this is I'm going to give you just a reading list. I don't even have the arguments on either side. We haven't really dug into that yet, although we eventually will. We'll try to. But I have a reading list. And these 3 books are all, they're either written by Antonin Scalia with a co-author. The first and third ones are Reading Law, The Interpretation of Legal Texts, and A Matter of Interpretation, Federal Courts and the Law. Those are both by Scalia with a co-author. And then Originalism, A Quarter Century of Debate, is an even more appealing book, I think, because Scalia wrote the preface, and some of Scalia's works appear. It's an edited collection, but it's a debate, an extensive debate over all the nuances of originalism. So I really think you want to get a copy of that if you can interlibrary learn it somehow. The numbers I put at the end of all these, I hope that you recognize them. They're the ISBN numbers, and I will add, this PowerPoint is going to be in the Google Drive. I've already uploaded it, so as soon as you have access to the Google Drive, you'll be able to highlight, copy, paste these. So if you're writing down these ISBN numbers, you shouldn't have to. Or if something goes wrong and you can't get to the Google Drive, we can easily email these to you. Okay, so on the other side, what do you do for arguments against originalism? And here what I would recommend, oh, I forgot about that. In addition to looking at what Antonin Scalia has written with various co-authors, you can also look for a couple of other people who write in defense of originalism or textualism, and those include Stephen Calabrese. Stephen Calabrese, I think, is actually the editor of that second book, Originalism, but he's also written a lot of other things explaining his position. Amar is a professor by the name of Akil, A-K-H-I-L, Akil Reed Amar. I think he's at Yale. And he's written a lot about textualism and how that's the best way to interpret the law. And then finally, Frank Easterbrook. So you can go digging for those authors' names in Lexis, especially if you link it up with originalism or textualism, and you can find some pretty good, detailed explanations of why that's the best way to read the law. Okay, so how about the other side? Let me try this again. 2 books I would recommend. The first book is The Invisible Constitution. Now that's by Lawrence Tribe, who is the professor of constitutional law at Harvard. And when you look at it, you're going to see right away that he is making the case that you can't interpret the Constitution just by reading the letter of it, that there is behind it an invisible Constitution that is, if anything, even more important than the wording of the Constitution. So I think you'll find a lot of ammunition in there to defend that in federal courts, which one of the things they are very concerned with is constitutional interpretation, the spirit of the law is absolutely indispensable. And the other book, the funny thing about Antonin Scalia, I don't know if you knew this or not, but he was a debater in high school and he was a debater in college. He debated for Georgetown University. A few years ago, when Georgetown tried to cut their debate program, Justice Scalia got on the phone and he said, "Don't you dare cut that debate team. I was on that debate team." And they said, "Whoa, yes, sir." Well, one of his rivals on the court is Stephen Breyer, who's another associate justice, and he was a high school debater. He didn't debate in college, but they actually, you can go and dig around on Google and you can find they did a public debate with one another on this issue. And actually, we could track down that link with probably 5 minutes of looking and just put it up in the Google Drive or maybe put it up on Twitter or the Facebook page or something, because not only is it entertaining to watch them go at it, but they actually go through a lot of these issues, and it's a good kind of beginner's look at that. But at any rate, the other book, I've been talking and talking, the other book is Active Liberty, and it's by Stephen Breyer. And it's Stephen Breyer's almost rebuttal to Scalia. And it's Stephen Breyer explaining what he thinks the role of the law is and why it is permissible for judges to look for the purpose or the spirit behind the law. So a place I think I would begin if I were you is to get very deep on those, the case for textualism and the case for these non-textual approaches. Then I have just one more thing. We're near the end of me doing all the talking. The one more thing is just a one different approach to this topic. There is a classic work by Milton Friedman, who won the Nobel Prize in Economics. And it's a short little article. It appeared originally, I believe, in the New Yorker. But if you put this title into a Google search, it'll pop right up. The social responsibility of business is to increase its profits. And it is cited all over the place. And it is Milton Friedman saying the idea of corporate social responsibility is bankrupt. That corporations have absolutely no burden to go out and do good in the world. All they have to do is stay within the law and maximize profits for their shareholders, and no other burden that you could put on business is defensible. And there are people who cite it approvingly, and they develop his argument even further, but you'll find other people who are really horrified by the position he takes, and they write arguments against it. And I think that's an alternate way that you could have this debate. Okay, so that's a lot of talking by me. Let me now figure out how to turn this off. And oh goodness, that was 25 minutes. I didn't mean to talk that long. That's my opening. So what I'm going to encourage you to do now is, if you have got another suggestion, if you want to ask me questions, or if you've got your own position on one of these topics, to unmute and let's have a conversation. Alrighty.
Should we start with Res 1 or Res 2 as far as discussion?
That's your call. Whichever one you're interested in.
I had focused a lot on Resolution 1, and I think what it's going to come down to, a question that I'm working on is the negative approach going to be saying essentially, does the affirmative have the burden of defending absolute freedom of speech? And the reason I ask this is I'm seeing a lot of negatives come back, and I'm seeing a lot of potential human rights, liberty cases, etc. People running and saying, look, freedom of speech is an indispensable right. Community standards are arbitrary, so we have to value the former above the latter. And what I'm wondering is, if negatives are constantly going to come back and say, if you have any limit on freedom of speech, you're not defending freedom, you're defending something more cut and dry. You're defending the prettied up side of freedom. Well, they could say any restriction that we impose that could be anything from not shouting in libraries to indecent exposure in public, and they can turn to say that's the restriction we're imposing, thus the moral standards are checked higher. So with that, is it fair for negatives to force that kind of a burden on affirmatives?
I think that you could probably say, and you'd have to double check whether I have this fact straight, of all the justices in the history of the Supreme Court, there are exactly two who've taken that position, Justice Douglas, Justice Black. They were both First Amendment absolutists. Everybody else, the whole history of the First Amendment, well, Oliver Wendell Holmes, I think, was the first person to put it neatly, but everyone else has agreed that there's a core that you've got to defend, that content-based restrictions are impermissible, that political speech is the core of the First Amendment, but free speech is not anything goes, that there are always necessarily, that sometimes there are time, place, and manner restrictions, but there are things that preserve the ability to deliver the content without there being, okay, the way I think you could put it kind of neatly, very briefly, is that all rights have balancing tests. There's no such thing as a right that doesn't have a balancing test.
Yeah. And of course, anything else is going good. Then I have a couple more questions, just thoughts that I'm bouncing around. Now this is just a question regarding the essence of community moral standards. Would it be viable for either side, for affirmative specifically, to come back and say that the negative is defending legal standards and not moral standards? Essentially, the question I'm asking is legality the only way to see what a community's moral standards are?
And I'm trying to think in what situation, what standard you would cite that you would identify as a legal standard where the affirmatives have room to say that that's not the moral standard. Do you have a negative approach in mind? Where,
okay, here's the scenario I'm picturing. Hate speech is brought up. Affirmative says essentially we have the right to speak our mind, and this is going to play well in conservative judges as well. I'm from Tennessee, so this is, every judge is going to vote against this. So they bring up hate speech, and the negative gets up and says, when they're citing the community's moral standard as being the laws that are presumed, like for example, Canada is a country that's allowed it, but assuming that some form of hate speech is discriminated against in a legal setting, which is really the only way how it can be binding, how we know what the standard is, would it be fair for a negative to get up and say you're defending a legal standard and not a moral standard? Because the legal versus moral argument in last year's Stoa resolution was all over the place. So if that is the case, if that is a viable argument, is there any way besides legality to see what a community's moral standards are?
Well, I can tell you that in this draft AC that we got put together in just a couple of hours, the examples that we had were interracial marriage and slavery and educating women. And in each case, the way that we tried to establish the clash between free speech and community moral standards was not to say that those things were against the law, but it was to find people in a position of leadership who called those things immoral. So we have a court case where the judge who wrote for the majority upholding the conviction for interracial marriage said explicitly, the state of North Carolina has made a judgment that this is immoral.
Okay.
So I think maybe if you've got that kind of pronouncement, that you could do that without just saying, well, it's against the law, and that settles the question of morality. But I kind of think that that's going to be a little bit all over the place, because I can't think of anything that's an indicia of community moral standards. I mean, talk about Scalia as much as we do. Scalia is very much about the argument, you can make them work for both topics, that all law is about collective morality, that stealing is against the law, not just by our whim, but because it's immoral. Same with murder. And so when people try to say you can't legislate morality, he's the one who likes to say, well, all criminal law is morality. So you might dig into what he has to say in his explanation for that, and that might help you.
That makes sense.
Cool.
Pardon me, but on that point that you discussed about interracial marriage, would it be reasonable to define freedom of speech in more of a literal sense, like actual speaking or political expression, whereas as far as the interracial marriage argument goes, that would be more of a freedom of expression approach rather than freedom of speech?
The first thing I think about that is what smart debaters are going to want to do is have their eyes squarely on the distinction between speech and conduct, because one of the ways Justice Black got away with being a First Amendment absolutist was that anything he couldn't defend, he just said, well, that's not speech, that's conduct. But The interracial marriage thing, what it says in that particular affirmative is not that interracial marriage itself was free speech, but the people who spoke out against anti-miscegenation statutes, when they spoke out in defiance of the community moral standards. And it was because they spoke that those standards changed. Does that help?
Yes, it does. Thank you. That makes sense.
Cool.
One more thing, just thinking. As far as negatives, the negative position right now that I'm looking at, if the app takes the resolution as a general principle or general rule, more true than false most of the time, what I'm seeing as a problem for negatives is having to defend community standards as a general rule, because those are totally arbitrary. If a community of, if what I talk about in writing this case is that imperfect individuals are going to create imperfect standards. So would it be a viable negative idea to interpret a moral standard as being the broad idea of maybe like the social contract or some sort of political theory, apply that and say this is the general moral standard of every community, or you have that, or the alternative of just picking one community moral standard and running with that as a principle in which the resolution would be false. So is it fair to take it through one lens, or should they take it as a social contract or something like that?
I think the first approach, the one you talked about, the social contract, is similar to that first approach I was talking about, that if absolutism is untenable, then the source should be what the community says. But to get to the other one, I think that what you could do is you could say the two halves of the resolution, as a negative, you could say this, the two halves of the resolution are, they're non-reciprocal, they're not mirror images of one another. You're talking about what is the limit on a right. And the fact that free speech is a right in the first place means that the limit is not going to be exercised in every case. So your burden as a negative is not to say that the two are perfectly balanced. It's to say that community moral standards, violation of community moral standards, is an incidence. It is a situation where realistically there needs to be a limit on free speech. And not necessarily in every case, I don't think, if you frame it that way. And I think you have to get back to the concept of the balancing test, that for the affirmative to win, they have to prove that there's no balancing test. But for you to win, all you have to prove is that the balancing ought to happen, that where community standards are violated, that's when the balancing happens, and very often free speech will win.
Mm-hmm.
Make sense?
Yeah, yeah.
Cool.
While we're on the subject, as far as a resolutional analysis point,
yeah.
Would it be reasonable to say that we're not discussing extremes? Like, because the negatives are going to come in and say, well, we're talking about, saying the F word in public. Would it be reasonable for the affirmative to say, we're not talking about the out of the mainstream, the extreme situations, but an overarching principle of freedom of speech? Would that be a reasonable res analysis point?
That's one that I think you ought to make. That, as I'm sure you don't need me to lecture you on, that's something that happens on absolutely every LD topic that there's grappling over. Do I get to pull in the extremes? Can I just talk about the sort of comfortable examples in the middle? If I'm negative, though, and I hear the affirmative say that they don't have to defend the extremes, I'm then going to point out how many landmark First Amendment cases have been about where can you use the F word. Tinker, the guy who wore the jacket into a courtroom that said F the draft. And that's a landmark First Amendment case. And so I would say our First Amendment analysis is radically incomplete if the affirmative tries to say that the extremes are off limits.
Okay, thanks.
I agree with that. And I think we also need to keep in mind that the resolution does say winning conflict.
Right.
So we're not talking about the parts where we're comfortable with what everybody's saying and doing. We're talking about where somebody's language or their beliefs are conflicting with our comfort standard in the community.
Excellent.
And then that's where we have to make a choice.
Yeah, very good. Yeah.
One other idea, and I may have hit on this earlier, as far as a negative burden, what they have to prove, how much of a restriction is necessary, and is there a type of restriction that's necessary? And by that I mean, I thought negatives are going to be getting up and talking about content of what you say. But would it be fair for a negative to potentially get up and say that we have a limit on when we say things? For example, like a baby can scream for Cheerios at home, and that's fine. But when it's in a library, that's a no-no by the social contract. Is a limit on just pure when, is that reasonable enough or viable on a negative?
Well, I typically think that you're in the best position in just about any LD debating when you have rooted the reasonability standard in the actual content of what it is you're debating. And when it comes to First Amendment law, there are a lot of different kind of lines of First Amendment law that could address that. One that pops right into my head, and I'm not an attorney and never went to law school, but limited public forum analysis, that sometimes in the past government has tried to shut down certain spaces and say in certain locations that you can't distribute political materials. And the court, in analyzing it, the various federal courts and the Supreme Court, in analyzing that, they've found that that's actually a content restriction in disguise. And they draw a distinction and they say, under certain circumstances, time restrictions, place restrictions, and manner restrictions are permissible, but they have to be narrowly tailored, and there has to be a fairly strong state interest in limiting those things. So I think that the one affirmative that we put up on the G drive, it defines restriction on free speech, or actually it defines free speech with a quote from one of Justice Thurgood Marshall's majority opinions in the First Amendment case, where he said restricting free speech means restricting content. The free speech is really about content. And I think that you do want to be very thoughtful and very strategic about, do you allow time, place, and manner restrictions to be considered restrictions on free speech at all? And the reason we wrote that into the affirmative was, if the negative were to say there are all these different places where speech in favor of interracial marriage, speech in favor of educating women would be disruptive, then we could say, well, then time, place, or manner restrictions might be appropriate, but that's not restricting speech. That's just saying, say it another time, go to another place and say it. So the negative's burden would be to say that the content needs to be restricted. So I think the point that you drove at in the first place, are those distinct? They're definitely distinct. And I think there's going to be kind of a spirited debate over what are the burdens, and it'll turn in part on that as well. So I think that's a good point.
Yeah, and I think a lot of it's going to depend on what the affirmative defines as freedom of speech. Like in the broad sense of freedom, I mean, time, place, and manner restrictions are restrictions, and they, of course, restrict freedom by definition. But as far as the pure speech side, they don't really change as much what you can say. It's just the freedom part. So I see that maybe lining up as a potential argument.
I think that's right. So we talked a lot about speech. Go ahead. So we've been talking a lot about speech, but does anyone have any thoughts about the letter of the law and the spirit of the law?
I spoke with an attorney friend of ours via Facebook, and he pointed out that a good argument in favor of letter of the law is that if a judge wades into the complicated discussion of what the intent and purpose of the law is, then he's wandering into a realm of subjectivity that causes him to encroach on the legislative branch, which raises a separation of powers concern.
That is right at the heart of the argument that Scalia usually makes in favor of textualism. He says everything that judges do, even if I think all of it is a good idea, go write your congressman. That's why we have Congress in the first place. And he also says that when judges consider the spirit of the law and they treat the Constitution, for example, as a living document, what that does is that politicizes them. And we never would have had talk about judges being liberals or conservatives or moderates if judges, he says that a judge ought to be an expert who's kind of like a plumber. And so you don't ask whether you have a conservative plumber or a liberal plumber. You just need a plumber who can work on the pipes. And so he's saying that's how judges ought to be.
Yeah, I think a lot of it, when I was first looking at this resolution, first of all, the key phrase in the United States federal jurisprudence, like with last year's Stoa resolution, I took both sides as a philosophical idea, and I didn't as much like bring a flow of applications out and pragmatic reasons why it's a good idea. Now, in the same way, when you're talking about the spirit of the law, you're delving into matter that's more thought-related as opposed to hard text. I think I think there's going to be a major gap, and it's just my ideas what the metagame may look like when apps get up and provide a very concrete, pragmatic, application-heavy case dealing with the letter of the law, and the negative gets up and says, in a philosophical world, in this sense, the spirit of the law has more weight and is the true meaning behind it, and therefore is more important or should have priority. And what I see apps coming back and say, kind of like what Hayden just said, is that if you give that power of just, oh, the spirit of the law has priority, that means that you would be allowed to basically void the letter of the law if what you think is the spirit of the law, giving way too much power to judges. So I think there may be a divide between people saying this has to directly apply into the United States federal jurisprudence. This has to have direct application. Okay, you talk about how great the spirit of the law is. How does this apply? Between that and the side that, philosophically speaking, the spirit of the law just owns the letter of the law. Letter of the law is lifeless. So I see that lining up as a divide, and I think it'd be wise if a firm just put in a resolution analysis, this has to have direct application in jurisprudence.
Sure. What I would add to that, though, is I think that you'll find that there are available some lines of decisions and some legal doctrines that can take the negatives end of it, the spirit of the law, and make it very concrete. And one of the things that would appeal to me that I think might be very, very appealing to your judging pool, although there'd be a big landmine in the middle of it, but this approach would be to talk about the Griswold line of privacy decisions. And the privacy line based on Griswold versus Connecticut is based on the penumbra. And to go back and read up on that, in the Griswold decision, the majority wrote that the first, fifth, ninth, and possibly a couple of more amendments, because of what they imply, because of the necessary assumptions behind those amendments in the Bill of Rights, there has to be a right to privacy. And that right to privacy has been extended to things like family decision-making. I don't think you'd have to go that far to find court opinions upholding the right to homeschool that were based in the Griswold line. And so I think you could say that the justices who said, I can't find a right to privacy anywhere in the Constitution because nowhere do I see the word privacy from start to finish, that those are the ones that don't give enough power to things like family decision-making because they can't respond to circumstances that nobody thought about back in 1787 because there wasn't universal public education, so the decision to homeschool was one that it wasn't a decision. So the big pitfall in the middle of it is that one of the Griswold line privacy decisions is Roe versus Wade. You don't want to get into that. But I think you could also say a tool can be misused. And the fact that you can murder someone with a hammer is not an argument to outlaw hammers. And the best friend that parents have ever had as far as having their parental rights upheld is the Griswold line, and that's all about the spirit of the law.
And there's always a divide. There's always a line between the letter of the law and the spirit of the law. Even if you paint it out exactly word for word, what the Second Amendment says, there's always going to be people on the liberal side jumping up and saying we shouldn't have guns. That's because no matter how explicit you try to make a law, there's always a level of interpretation that goes into it. And I mean, the Bible is the best example of that. It's painted out, it's 1,000 pages long, and yet people can get hung up on every single verse. And one large application I see, and this may be used heavily as I live in the Mid-South, like, for example, the idea of the Second Amendment says we have the right to bear arms, but liberals get around this to say, oh, well, we can take away your ammunition, right? It doesn't say in the Constitution we can't take away ammunition, right? And the obvious implication is that no, sure, it doesn't say that. Of course, but the meaning of the law is this. So it's an application I see lining up.
Sure.
Yeah.
Yeah, one of the things that ought logically to be a viable strategy for the negative, but that I wouldn't think much of its execution value in actual debates, would be to talk about the interpretive difficulties and just how language works and almost get into linguistics. But I think about trying to make that argument accessible and appealing to judges who are hearing it for the first time, and it just seems like a nightmare. It's one of those strategies where you should be right, but you're not going to win with it.
Yeah, exactly.
His first year of law school at Georgetown, and he was telling me about how there have been a lot of cases, and I wish I could remember any of the exact ones he cited, where there was a criminal who clearly was in the wrong, but he was let off because the police had some kind of error in the way that they handled the situation. For instance, they did not make sure he understood his rights or they mistreated him in trying to get information, or simply the fact that evidence that is obtained illegally cannot be considered in court. So I think that poses an interesting conflict between this guy is clearly guilty, should we uphold the spirit of the law and execute justice, or do we need to follow the letter of the law in the interest of making sure that police don't give, that police have a high incentive to follow the law in future cases. So I think there's probably applications within that, and hopefully cases won't come to a rundown of cases. Debate cases won't become a rundown of so-and-so versus so-and-so, but I think that there's some possibility in there.
There's enormous potential in that. That is a great idea, that technicalities tend to be about the wording of the law and the fact that the law is imperfect. One of the examples that, okay, there's an article that Richard Posner wrote. Richard Posner is, I believe, both a federal judge, or used to be a federal judge. He's also a law professor at the University of Chicago. Considered very conservative legal mind, but he and Scalia just go round and round, and Posner does not believe in textualism. And one of the examples he likes to trot out a lot is, if the city passes a law that vehicles may not enter the park, you can't drive your car into the park, does that cover ambulances? Well, if you're a textualist, you think that it should be illegal for an ambulance to go pick up someone who's having a heart attack in the middle of the park, because the law just says vehicles. And I think you could probably collect a fair number of examples, and you don't want to turn it into application war, but still I think you could make it fairly compelling that where the law does not stretch to cover the facts of the situation, that is an endemic problem, and that's a really strong defense for the spirit of the law. I like that.
I see another approach lining up on negative. Like we've been at the dichotomy of like, okay, somebody has allegedly broken the law, do we let them off? Like, for somebody has jumped in a pond that says no swimming to save someone, what do we do here? I see, because it uses the word jurisprudence, it's not necessarily limited to specifically condemning or justifying an individual based on a law violation. Meaning that another idea I was thinking of is, could they just take it to the level, like a negative could say, which has priority? Okay, let's see. Have we ever changed the spirit of the law to match the letter of the law? Ever, in any case whatsoever? Of course not. Now, the turn on that is essentially saying that what's most important is based on what we always adhere to. We always try to adhere the letter of the law to the spirit of the law 99% of the time. Why do we change laws constantly? So that idea of just exempting court cases, exempting individuals being justified or condemned could line up in, that's just one idea out of probably tons in which you could argue totally outside of that it's still important, it still has priority just based on regular procedures.
Of course, if that was an argument that I was hearing a lot, and a fairly good counterexample popped right into my head, which was the 1964 Civil Rights Act, and the provision in there about discrimination based on gender was added at the last minute to try to sink the law. So that was language added to the law, the letter of the law, and it changed the entire spirit of the law, because it was treated as absurd when passed, but it became part of the spirit of the law that unequal pay for women in the workplace was unacceptable, and societal attitudes changed as a result of the law. So I think I would go out and I would collect 4 or 5 examples of that and say, I'm sorry, I can turn your example on its head, that the letter does sometimes drive the spirit. Because law, and really the phrase you want to search for on this, and there are a number of legal theorists who write about this, that the law has a pedagogical effect. They'll use Brown versus Board of Education as one of the leading examples of this, but there are other ones as well. So if you're grounding it in that claim, then I think you may find that people upend it patiently with some counterexamples.
So that counterexample specifically, you're saying in the last minutes, the Civil Rights Act, it was added that you could not discriminate against gender, and that changed the spirit of the law?
Yeah, it did. Because, go ahead.
Go ahead.
No, I'm interested.
Okay. Could you explain to me how exactly that parallels? I'm getting a little lost.
Okay, I missed that last part of it because of the bad microphone.
Okay, I said, could you explain how that parallels exactly? I'm getting a little bit lost.
How does that parallel? Okay. Maybe you need to walk me back through your argument again, because I was on top of the premise that the letter of the law, that the spirit of the law drives the letter of the law, not the other way around. And the first place my mind went was, no, sometimes the letter of the law drives the spirit of the law. So talk to me more about the back end of your argument, what the implication is.
it wasn't just that we derived the letter of the law from the spirit, but more of the idea that in any good system, the letter of the law is lifeless by itself. It's totally lifeless. The letter of the law is there specifically just so that judges can interpret it and make fair decisions without having too much leeway. Well, the counter to that, looking at the other side of the glass, is the idea that we always form the letter of the law to match the spirit of the law. And even with the example where we added the wording and changed the spirit, we wanted the spirit to be there, and thus we added the words to match that. So it's the idea that the words are always made to adhere to the spirit. We don't change the spirit to match the words. We always change the words to match the spirit.
And that's exactly where, if you go and read up a little on the history of the Civil Rights Act, and in particular adding gender to it, that's where I could turn that argument on its head and say, sometimes things have made it into the law that seemed implausible at first, but when they became the law of the land, the attitudes followed. And we wound up glad that they had. And gender was never meant to be part of the Civil Rights Act.
Gotcha.
Pardon me just a second. It also could come down to a matter of, or a question of agent, because the resolution says in the United States federal jurisprudence, even if that's true, even if the spirit of the law does drive the letter of the law, once it comes to a courtroom, the spirit of the law question has already been settled. And at that point, it could be argued it would be the judge's responsibility to administer the letter of the law, and the place for the debate about what the letter of the law should be pertaining to its spirit should be in a legislature. So even if that's true, it still could be argued that debate should be settled in a state house rather than a courthouse.
Well, help me understand this then. If you've got a 3-judge panel who are hearing an appeal from an ambulance driver who drove the ambulance into the park to save the heart attack victim, and 2 judges vote to acquit because they say this law was set up for public safety, so saving someone from a heart attack is in line with the spirit of the law, and the 3rd judge says the law is the law. I mean, your opening premise was, by the time it gets to court, the spirit question is settled, and I'm not sure that's true because of the limitations of trying to apply just the letter of the law without taking into account what the purpose of the law was.
Right, I see. And that could be, as frustrating as a situation like that may be, that could be just what society needs. And I'm just thinking out loud here. That could be what society needs to make the determination, because at that point, society could decide, well, maybe we need to change the law. But if judges just make that decision without consulting society, we may never know about the flaws that are contained within our existing statutes if decisions that do not reflect common sense are not made to indicate to us that we have a problem.
That, you just nailed one of the really important points of stasis on this topic, because what some people will say is, that's what Scalia loves to say. Scalia says go out and write a better law. That if I read the law before me and explain what the law says, and it produces a perverse result, then improve the wording of the law. But there are other people who make a pretty compelling case. The way language works, you can't ever write the law so perfectly that it covers all situations. And so you have to assume that the people who will carry out the law have some common sense. And if they just blindly use the surface meaning of those words, then they all come across like they have autistic spectrum disorders. And so that, I think, is where there's going to be a spirited debate, because there's the abuse of discretion on the one side, but then there's the unsustainability of this dry application of the law without consideration of context. And you may actually have to get into how language works and how language without context is completely meaningless. I think that might be one of your foundational points.
That's true. That's very true.
Could it be argued, one of my friends was thinking about this, he's doing LD for his first year, and he was thinking about running a sort of either res critique or res objection based on the idea that the letter of the law and the spirit of the law are mutually codependent. And that if you instantly value one above the other, you're either going to give a dramatic shift in power, or you're going to give this blind, rigid focus that's going to ignore the importance behind legislature.
The balance negative. I mean, I think there are some arguments you can make on just about every topic against balance negatives. I don't think there's anything about this particular subject matter or this particular wording that makes it a less winnable argument than on other topics. So yeah, I think you could say that neither one makes sense without reference to the other, you then have to win that there's so little distinction between them that, well, yeah, I think that is a viable strategy, is where I wind up on that.
And one more thing, to be talkative guy, but one of the things I'm thinking about, like same thing with the negative in the first res, is you don't want to take community standards as a whole and just say every community standard or most. You want to boil down into something like the social contract. What I'm thinking also on negative is, could negatives run a resolutional analysis and talk about the spirit of the law and boil every law down to essentially the protection of human rights, and say that at its core, laws, the spirit of every law, the intent is to preserve human rights. So when you examine when in conflict, if we can understand the spirit of the law was made for that protection, if that is indeed the case, and we accept that premise is true, when we're looking at conflict, the letter of the law doesn't inherently uphold human rights. And if those two are in conflict, you have to choose between protecting the spirit of the law, which is made in order to protect human rights, and then looking also at the letter of the law, you always have to choose a spirit to essentially uphold the value. Building on that, though, the second leg of the argument is the resolution. The problem I see with that is that the resolution doesn't specify laws that are inherently moral. So these could be laws that are incredibly and are based on that, but it does, once again, it does say in the United States federal jurisprudence. So you have to look at which laws. I'd say most laws of the United States are moral. I'm no court expert, but generally speaking, that seems like the purpose. So does that seem like a viable strategy?
The first thing that occurs to me is that I think as your opponent, I would say that you pulled the camera way too back if you think that the spirit of all law is just upholding human rights, and that there are conflicts that happen between the letter of the law and the spirit of the law that depend a lot more on what specifically the law is to determine what the spirit of it is. So the spirit of traffic law is to maintain the flow of traffic, but the spirit of burglary law is make sure that people don't move in and out of places without permission. So the spirit of those two laws are the exact opposite of one another, but when you say that the spirit of all laws is to uphold human rights, you make those two equal.
Mm-hmm. Yeah, it makes sense.
Mm-hmm. We have just a couple more minutes. Does anyone have a thought or a suggestion that you've been sitting on that you really want to get out there?
There was just one more thing I was going to mention pertaining to the, pertaining to the community moral standards resolution. I think maybe a lot of people are going to automatically think like Christian morality or conservative morality, when indeed it could mean Sharia law or even secular ideas such as humanism. So I think, I'm not sure if it would be wise for the affirmative to take the approach, kind of the opposite of our automatic reaction to that, and saying like Christians or religious folks should be able to speak out amongst a society dominated by humanists or secularists. Just wanted to throw that out there.
Very definitely, and I think the religion and the public sphere, if that affirmative was going to be viable, you would have to say that across most of the United States, the community moral standards, or at least in some sizable communities, the community moral standards where the religion does not belong in the public sphere, and that would set you up to make that argument. The thing that we have up in the Google Drive where I talk about educating women, the example actually, part of the example is Malala and the Taliban. And another part of the example is Boko Haram and the girls that they've kidnapped to sell into slavery because they were going to school. So yeah, very definitely the affirmative may want to lay out at the beginning that the negative doesn't get to define morality as just our morality, but it's morality in any community. That's a good point.
And a quick look at applications. I was thinking about World War II and other examples. I'm seeing a potential turn by negatives if apps get up and talk about a community moral standard that's inherently bad, and they talk about it set up by some sort of government, especially one that's tyrannical. And a problem I see lining up with that, and the negatives could flip on their head and say that, no, your example has to mean community standards. It can't just be one individual within a community who's received more power. It has to be a collective democratic standard, which, again, appeals to the idea that legal standards are going to be the main application, main source for that. So, linking back to my question, is it legal, is it moral? I'm not seeing a whole lot of ground on the other side. I think it's going to have to boil down to that, and it has to be, can't just be one individual. It's got to be societal. It's got to be democratic.
Well, possibly. I think the first thing that occurs to me is if I wanted to hold on to the interracial marriage example for the affirmative, and I didn't want to say that morality was determined by law, I would just point out all of the lynchings that happened as a result of interracial relationships and say that community self-help and vigilante law is a pretty good measure that there's a sizable part of that community who with impunity can go out and take the law into their own hands. So I might offer that as a counterexample. Well, it is 2 o'clock. You have been doing some really good thinking. I really appreciate people coming and taking part in this. We're going to release the Google Drive in probably the next few minutes. And, you know, anything that we can do, you want to email me follow-up questions or anything like that. Our objective is to try to give you some resources that we hope will be helpful.
Thanks for putting this on.
You are very, very welcome.
Thanks so much, man. We'll see you around.
Indeed.